I'm Spencer Mazyck, and this is another installment of our legal guide to starting a technology company. Joining us to discuss the importance of guarding your intellectual property is Mark Radcliffe. Mark is a partner at DLA Piper, and he concentrates in strategic intellectual property advice. And Mark, we're hoping that you will share some of that great advice with us today. Welcome, and thank you for joining us.
Thank you, Spencer. I'm happy to talk with you.
So in guarding your IP assets, let's talk about the company's name, because we know that you're supposed to register it with the Secretary of State, but is it also advisable to register the company name as a trade name or trademark?
Well, that depends on your strategy, and I think it's very important to have an intellectual property strategy. Trademarks have a variety of strategies. You can either be like Procter & Gamble, where Procter & Gamble doesn't really appear, and what they use is Tide and other trademarks. Or you can be like Adobe, where your trade name or your company name is the same as your trademark. The problem with using your company name as your trademark is you may end up having more than one product line. So what do you do in that situation? Also, you need to make sure that your trademark is available throughout the world, and that may be a challenge. There's over 180 countries that have trademark laws. Now, from a commercial point of view, there's probably only 40 that are important. But if you're using your brand and your name, that can have some advantages, but it can also be a disadvantage if that name is not available in another country.
So aside from company's name, the startups generate a fair amount of intellectual property. So how do you recommend that they protect that IP from their employees?
I think there are three important steps for any startup. First of all, you need to have a plan. You need to make sure that your intellectual property strategy is consistent with your business strategy. So, for example, if you're entering into a marketplace that has a lot of large incumbent companies that have large patent portfolios, you need to understand that they may try to use those patent portfolios to keep you out. So that means you need to start filing patents early on. Also, if you're in a marketplace where you've got competitors that are well established, you may want to make your software available on an open source basis to make it a standard. That's, for example, what happened with the Apache software, which is used to run many web servers and beat out IBM and BMC. So first, strategy. Second, and you need to have think about patents early and often. It takes 3 to 5 years to get a patent. So if you file for a patent the day after you incorporate, you won't have it for 3 to 5 years. The third leg that for startups is you need to make sure that you own your IP. I've seen numerous situations where somebody was involved early on in the process. Maybe they hadn't set up the process for making sure they got assignment agreements, and that person leaves, and now when the investor comes and he says, well, I need an assignment from that guy. In one case, a CTO took almost 6 months to negotiate, or he's a former CTO, to negotiate a deal. So very important to get that done early. And that can have an effect on your exit.
Back to the original question to Mark in terms of protecting that IP, the intellectual property from your employees, would you suggest that they do non-disclosure agreements? What other types of agreements might come in handy here?
Well, every employee should sign an employee non-disclosure and assignment agreement. And if you're working with a law firm that's familiar with working with startups, they'll have a standard form. They shouldn't even charge you for it. As a matter of fact, at venturepipeline.com, we actually have a free form that you can kind of fill in and get. You also should have all of your consultants sign assignment forms, because if they're creating intellectual property, you need to have them sign the same agreement. And finally, you should have a set of non-disclosure agreements, which you use regularly when you're talking with customers or prospective customers, because in order to claim something as a trade secret, you need to have taken reasonable steps to maintain its confidentiality.
Well, which brings me to a question, though. Is a VC investor going to sign an NDA in the early stages of negotiation?
No, venture capital investors do not sign NDAs. And that's just the nature of the process. They see hundreds of companies. They don't want to be restricted as an NDA would restrict them. So basically, you have to make the decision. If you want the venture capitalists to invest, then you're not going to get them to sign an NDA. The one exception to that is corporate investors who are more used to NDAs, don't do as many investments. They will frequently sign an NDA before they talk with a company about an investment.
Which I guess that means that startups ought to be very careful about what they disclose, at least in terms of how much IP they disclose in the pitches that they make to these VC investors.
That's absolutely correct. And in some ways, it's a gradual process. You should have a slide deck that you feel comfortable just giving to anybody without any confidentiality attached to it. And then as you move forward and you get into the due diligence, you will be revealing more and more about the technology.
Well, and Mark, you mentioned patents, and I know that this answer to this question may vary, but I have to ask it anyway. What can startups expect to pay for a patent? What's the range?
So let's first of all understand, as one of my patent partners says, asking the cost of a patent is like asking the cost of a house. You need to think about how big is the house, how many rooms does it have, what sort of finishing does it have, what have you got for the floors. So the answer is it varies depending on the technology, depending on how many patents there are that have already been issued, because you can't override an existing patent. But I think a startup should be thinking about $10,000 to get a patent that's worth something. And it could go as high as $20,000 or even more depending on the nature of the technology.
Does software qualify for patent protection? I know that you can copyright it.
Software absolutely qualifies for patent protection, particularly in the United States. In Europe, the situation is a little bit more complicated, but the truth of the matter, people have gotten software type patents in Europe for some period of time, even though software as a category is not patentable in Europe. But there's some tricks of the trade where you can get similar type of protection.
Okay, Mark, so we only have a few minutes remaining, but I want to ask you, in guarding your IP assets, is it equally important for startups to make sure that they're not infringing on another company's intellectual property?
It is important at a certain level. The problem is that there are millions of patents out there, and patents in the U.S. are secret for up to 18 months. So even if you did a complete patent search today, tomorrow a patent could issue which it directly reads on your technology. And frankly, if you know about patents, then you could be a willful infringer, which means that you could have treble damages. So most startup companies basically choose to go forward and not know a lot about patents because of the risks involving in that knowledge.
So ignorance is bliss, huh, Mark?
Ignorance is the proper strategy, and it's bliss.
Well, thank you very much for sharing your insight with us today. We really appreciate it. We're going to have to leave it there. That's Mark Radcliffe of DLA Piper. Stay tuned for the next installment of our series. But in the meantime, for more information on this or other topics, subscribe to BloombergLaw.com, and you can follow us on Twitter. Thank you for joining us. Bye, everybody.